last day of national workshop. I humbly request to our guest speaker, Principal SangitBhavan and Head of the Department on dais. Ma'am,
From this side.
now I request for traditional ballroom.
Right. Negligence from your part. है ना?
Now, I would like to introduce our today's guest speaker. Dr. Somabha Bandopadhay is working as assistant professor at the National Forensic Science University, Delhi. She was earlier associated with the West Bengal National University for Judicial Sciences, Kolkata, and was also associated as a university junior research fellow. She pursued BA LLB from School of Law, KIIT University, and pursued LLM, National Law School of India University, Bangalore. She was awarded the Nani Palkhiwala Memorial Gold Medal at NLSIU, Bangalore, for securing the highest in LLM, Human Rights, and the Chancellor's Gold Medal and Nani Bala Devi Memorial Gold Medal for securing in the highest in School of Law. KIIT University in 2018, Dr. Somabha ma'am was awarded the Indo-Canadian Shastri Mitex Research Scholarship in 2022 to pursue research on victimization of transgender persons to visit the School of Criminology, University of Montreal, Canada. She has 3 books and over 40 articles to her credit. She is a classical Manipuri dance artist with the extensive knowledge of law and performing arts. Today's the title of lecture is Copyright in Performing Arts, Decoding the Law for Performers. Today's lecture will aimed at empowering performers to understand the nuances of law in India with regard to the protection of rights as performers, choreographers, and directors. The lecture will also focus on a specific online platform for performers in the present day and the contractual obligations that arises in this process. So, I request to Somabha ma'am for their lecture.
I have to ensure that I am around this.
Yes.
So that
আরো রিলিজ করে মানে আরো পেছন থেকে
I'll not know.
बहुत ज्यादा मूवमेंट
हाँ, wireless है। हाँ, ठीक है। हाँ, ठीक है। I will ensure that I'm around. ठीक है।
আরো পেছনে করে আরো পেছনে করে অনেকটা তাহলে ফ্রেম হয়ে যাবে
So, very good morning to all of you. Apologies for being a little late. That's was a little out of my control because the train was a little late. So, this in fact is special for me because I am here being invited as a speaker, and this came to me from Amitji, and it so also happens that the department in this entire School of Performing Arts is being headed by my mother. And she was absolutely unaware of the fact that I am the one who is one of the resource persons for the workshop. So, and it only came to her knowledge when, the proposal was placed and all of it happened. And so hence it's very special for me that I'm here. And I just got felicitated by my mother and my guru, Professor Dr. Bandopadhay. And my entirety of what I do in terms of performing arts is, of course, credited to my parents. So without acknowledging that, I cannot start today's lecture. And of course, that's why it's very, very special and emotional. So thank you, Amitji, for giving this moment to me. Thank you very much. So now to really begin with what is performing arts and in terms of law. Okay, performing arts, I believe all of you are aware much more than I am. But where is it that we see the interconnection with law is what I am here to kind of just facilitate. I always say that I have nothing to really teach. I can only just tell you certain things from my experience. And I hope I can get some more experiences from all of you as well. Because what I'm going to talk about is more about the practical implications. What is happening actually? You feel it. And more than the law, I will tell you that part. How do you tackle it? Or how can you tackle it? So for that, I will begin with a short clipping of a production of ours, Jai Jai Bhanu Jai Javatdeva. It was conceptualized and choreographed by Professor Dr. Bandopadhay, and direction was by Professor Dr. I'll just show you one little clipping, and then I'll show you a photograph. And then we'll, as I said, that there are practical implications of what I'm going to talk to you all about today. Let's just see it first, and then I'll continue. And this, of course, is publicly available as well. So even if you want to watch it later to try and understand what I will be speaking, that also definitely works. Go screen share. That is also related to what I will be speaking. That, many times we do not know that our videos are being used, and there is earning that goes to the companies who are actually placing advertisements on our videos. So
First thing is you have to have a alkaline one, and body can only be made alkaline.
This one that you see, so this that you see, can anyone of you tell me whether you have ever seen this kind of a costume, and especially what we are wearing on the top? Have you ever seen anywhere? In the Ras Leela, yes, Manipuri Ras Leela we wear it, but not in the same manner in which it is there, right? So this is creativity, whether you like it or not like it, that is your personal perception. We're not going into aesthetics or anything of that kind now. But this is the creativity that you see of someone who has choreographed it, someone who has conceptualized it. As artists, we have artistic freedom to do that. All right. Now I will show you, as I said, a photograph. And this happened in 2009, 10, 11, around that time. And the photograph is a screenshot I have taken from a status update over WhatsApp just about 2 to 3 weeks back. Okay. Now this one. This is the photograph. Okay. And this was not a part of a production because we have not been staging that production for almost about 7 to 8 years now. So this was, and interestingly, this is someone who has performed with us, is a disciple of Bandopadhay. However, so that's different part of it. I'm not coming to that right now, but just look at how something, a creativity which was used by someone in a production was copied and pasted and put in a different context. And rather, this actually happened to be in SangitBhavana itself. And Jai Jai Bhanu Jai Jai Deva is a production which has been conceptualized by keeping Jai Deva's Gita Govinda on one side and Tagore's Bhanu Thakur probably. So now you see, the first one is the original production where someone created something new, something different. And this production has been performed across the country and even outside, abroad. So there is an identity of that costume that I showed you with the creator, with the one who choreographed it. And that identity, without permission, is being taken by somebody else and is being put into their own way. This is exactly what I believe a lot of us face today. A lot of you on YouTube, and whenever I've had these lectures, I've heard that a lot of people get a copyright hit the moment they are using some song or they are using a choreography. Somebody is, saying that, this was mine. And I have plenty others actually to show, but I just thought of taking up this one. So you see that now we can close all of this. We can go back to the panel because now I'll move on to the discussion. So that is the problem. That is the problem why I think I am here today. That many, often than not, whether we are aware or not, our creativity is getting stolen. Our creativity is being taken away and we are unaware of it. Now the problem is when we are big shot, very famous people, it comes to our knowledge somehow. But if it is of some struggling artists, some young emerging artists, then no one really bothers. What will that artist do in front of someone who is gigantic? And this is a common problem that we see. The next problem that we see as artists is when I use a music, I do a video, I do a reel, and then a part of it is simply censored or banned, it's muted. That's a problem. Not every one of us can afford to actually get a music recorded. Cannot have our original music. So the ones who create original music, they are the ones who claim copyright over it. And so the problem is that we cannot use it freely. Then what do we do? What do we do? How can we go ahead with our creativity? Does it mean that we need to essentially have a lot of money to be able to create something new, something different? Is that what the law is saying? Is that what law is asking us to do? So how do we earn? An artist's life is very difficult, right? How can an artist who gets very minimum amount of payment by performing be able to record original music and be able to perform? These are problems I believe a lot of you do face, right? And that's the contemporaneous of the problem that we are speaking about today. So with that now, I hope I have given you the background of why we are here today and why this topic in a national workshop, right? I hope I could give you a sense of your statement of problem or the context of what I'm going to be speaking. So to really begin with the very essential and the basics. What is law? Let's start with that. Because I'm not speaking to anyone who has had an orientation of law, I believe. Anyone who knows what a law is, even the participants over Zoom. If you want, you can simply raise your hands. Your perception of what is law? Please, anyone, let it be interactive. Anyone? Yes.
Law is the rules that protect human rights and their ethics. Isn't it?
Okay. Okay, so it is protecting rights and ethics. That's what you say, right? Okay, ethics. Okay. Anybody else who wants to try it? What is law? Anyone else? Anyone online? Is there anybody responding online? No? Okay. So yes, so roughly that is what it is, but it is much beyond that. And what is law? There are a lot of definitions of it. Let me just give you some words which you can relate to and which you can possibly take back with you. One is that it is a system of rules. Second is that law is what is being written by the lawmakers. Lawmakers meaning the parliament, state legislature, that is law. President in certain times can also make law. That is also law. The judges also make law. That is coming from the courtroom. That is judge-made law. So that's why laws are those essential diktats of either the parliament or the judiciary or the president, that is executive. So basically, some very basics of political science. We know that we have legislature, executive, judiciary. Everyone has power in some sense to give you some law, which is for the purposes of protection of the rights. Now, rights of whom? Rights of the people for whom that law is being made. So if a law is made for a company, then it's company law. If a law is being made to protect against transfer of property, it is property law. If it is made for artists, then it is known as copyright law. If it is made for someone who is making a new design, like let's say your Apple laptop or your Samsung phone or your Pepsi bottle, that is different law for them. So law is that system of rules or body of principles to protect certain rights. Now, if that I have laid down very clearly to all of you, I hope the ground is clear as to what is law. Right? In like about 2 minutes, in the most simplest way that I can explain to you what is law. Now, why do you need to know what is law? Is because only then you understand what is known as intellectual property rights law. Intellectual property rights law is the law that protects the rights of those who are making an intellectual property right. Intellectual property. अब ये intellectual property है क्या? What is this intellectual property? Property तो पता है सबको property क्या होती है? Property ये भी property है, मेरा watch property है, सब कुछ property है, बस मैं property नहीं हूँ. एक जमाना था जब women को भी property बोला जाता था. Women used to be property, but we are much past that age, right? So everything that you see is property. Either it is movable property or immovable property. But उस property का एक form है, touch कर सकते हैं, उसको feel कर सकते हैं. But जिस property की मैं बात कर रही हूँ अभी, that is intellectual property, which you cannot feel. क्यों? Intellect कहाँ होता है? Brain में कहीं तो होता है. I am not a neuroscientist who will be able to tell you where in the brain exactly is the creativity. There are lobes, it seems, as per science, where the creativity happens. So that can you feel? Can the law feel that? But using our intellect, we make a property. So now should we protect the property that is made? Or should we protect the person's intellect who actually made it? What do we do? What do you think we should do? Should we protect the property? Or should we protect the intellect of the property? Is it complicated to understand? What do we protect? Because I said that law protects the rights of some people who is the subject matter of law, right? So we protect both. Intellectual property rights, we try to protect both. And this comes from the very basis of intellectual property law, which is on a triangular tripartite structure known as the Lockean labor theory. Lockean labor theory comes from labor theory, and John Locke had given this theory, which has been superimposed into intellectual property rights to understand what is intellectual property rights. In very, very simple terms, it means that जो लेबर देता है कुछ चीज में, मेहनत जिसका है, राइट उसी के पास. लेबर जिसका है, राइट उसी के पास है. As simple as that. So the one who is putting in the labor, that is the person whose rights have to be protected. So, as a dancer, my right will be protected. As a performer, my right will be protected. As a choreographer, my right will be protected. As a broadcaster who is simply broadcasting it, my rights will be protected. तो ऐसे बहुत सारे चीजें हैं जिसको लेके इंटेलेक्चुअल प्रॉपर्टी राइट्स लॉ बनाया जाता है. Now this intellectual property, अब बस I want this to be interactive. Intellectual क्या चीज से हो सकता है? Artistic तो हमें पता ही है because that is what we are doing. But apart from that, creativity और क्या चीजों में हो सकती है? Anyone, please. Literature, yes. Someone said literature. Design.
Scientific
Yes.
innovations.
Scientific innovations, yes. Mathematical, logical, okay. Cooking. Interesting. Yes, yes, indeed, it's an art.
Ma'am, sports.
Photography, sports. You mean sports, the way you run that creativity? Usain Bolt, that kind? Or
Yes,
Milkha
ma'am.
Singh?
Ma'am, choreography of a dance.
Choreography of a dance, yes.
Ma'am,
Drawing?
drawings.
Yes, drawings. Music?
Singing.
Movie
Singing.
scripts, okay. Cinema, okay. Drama,
Singing.
singing,
Theater.
theater, yes. Drama, yes. One's own voice. Ah, that's yes. Sharad Kaekar recently, he was there for a conference last year and he said that काश मेरे voice को मैं कुछ कर पाऊं ताकि मेरा जो voice है वो AI use ना करे, you know. Sharad Kaekar said that.
अमिताभ बच्चन के वॉइस पे
हाँ वो भी हो रहा है. Yes, yes, yes. जी. But voice इंटेलेक्चुअल है क्या, उस पे क्रिएटिविटी कुछ है क्या? somebody is born with a good voice, somebody is born with a shrill voice. क्रिएटिविटी का बात भूलना मत यार. क्रिएटिविटी is there. Storytelling, that's an art of speaking, okay. It's performance, some sort of performance, okay. और कुछ लिटरेचर में आ जा रहा है, चलो पोएट्री, हाँ. और कुछ ठीक है, परफॉर्मेंस, ओके. डिजाइन जब करते हैं,
Ma'am, painting.
यस.
Painting.
पेंटिंग, यस. पेंटिंग, यस. फैशन डिजाइनिंग, डिजाइनिंग ही हो गया. यहाँ पे स्कल्पचर है ना, कला भवन तो बस इधर ही है. स्कल्पचर तो किसी ने बताया ही नहीं. स्कल्पचर भी तो आता है उसी में. फैंटा का बॉटल और पेप्सी का बॉटल अलग होता है. स्प्राइट का बॉटल, कैंपा कोला का बॉटल अलग है, राइट. दूर से लेज को देख के पहचान जाते हो कि ये तो लेज ही है. आजकल तो उसका और भी कुछ कुछ आने लगा है, बट ओरिजिनली स्पीकिंग है ना. तो ये जितना भी सारा आपने बताया, ये सारे के सारे ही इंटेलेक्चुअल प्रॉपर्टी राइट्स के द्वारा प्रोटेक्टेड है.
Ma'am,
But-
design of a instrument.
Yes, design of an instrument. Yes, indeed. But as I was saying, all of these intellectual property, सबका protection है. But all of this is not copyright. It is not copyright. And this is where I wanted to bring to all of you that there are different branches and different laws in protecting different kinds of intellectual property rights. Copyright is one of them. The other is patent. Very often we hear, मुझे अपना म्यूजिक को पेटेंट करना है. नहीं हो सकता. And that's exactly the reason why I'm coming to the different branches. So copyright is one, patent is another, trademark. ये जो लेज आप देखते हो बाहर कहीं से, एप्पल का जो एप्पल होता है ना, हाफ ईटन एप्पल, राइट. That is trademark. Then you have designs. Then you have geographical indications, GI, right? Santiniketan में है हम लोग, so Santiniketan leather and katha stitch, GI products of Santiniketan. They are intellectual property, but they are not copyright. So ये जो मैंने different terminologies बोला, एक एक करके इसको decode करते हैं, ठीक है? Copyright पे मैं आऊंगी, but उसके पहले trademark. Trade word use है, which means commercial है. Trading करने के लिए, trading means in simple terms, खरीदना और बेचना. To sell and to buy is what is in simplest terms trade. So that mark which helps you in trade is trademark. एप्पल का हाफ ईटन लोगो देख के आपको पता चल जाता है कि एप्पल है, आई वांट टू बाय एप्पल, तो मैंने खरीद लिया, है ना. सेम विथ लेस, Same with maybe kurkure. Same with luxury cars. है ना? क्रेटा को देख के जिनको कार का थोड़ा सा वो है, क्रेटा को देख के समझ में आ रहे थे क्रेटा है कि ब्रीजा है. फरारी को देख के समझ में आ जाता है. Like that, you know. There are certain atypical features of certain brands which are related to their mark, the trademark. So that trademark is that mark which helps in the selling and buying or trading. That's it. अब वो mark जो है, that is also an intellectual property. इसीलिए उसको protect करते हैं. जैसे आज अगर हम लोग ये एप्पल वाला देखते हैं, बहुत ज्यादा डिस्टिंक्ट है. वो वाला जो मार्क है, वो we cannot get confused with anything else. That only and only Apple products, right? So वो किसी का क्रिएटिविटी था ना. ऐसा आधा खाया हुआ एप्पल को मार्क बना दिया पूरे विश्व में. क्रिएटिविटी था, राइट? सो जितने भी बुक पब्लिशिंग हो कहीं पे जैसा ट्रेड मार्क, जैसे विश्व भारती का जो लोगो है, दैट इज ऑल्सो अ मार्क फॉर प्रोवाइडिंग सर्विसेज, एजुकेशनल सर्विसेज. तो ये सारे के सारे प्रोटेक्टेड होते हैं. सो वी आर नॉट टुडे टॉकिंग अबाउट ट्रेडमार्क, बट दिस इंटेलेक्चुअल प्रॉपर्टी. सेम गोज विद डिजाइन. फैंटा का बॉटल, पेप्सी का बॉटल का जो मैंने बताया, लेस का जो मैंने बताया, ठीक है. या फिर अगर आप लेट्स से सीसीडी में कॉफी पीने जाते हो या कुछ ऐसे स्टारबक्स में कॉफी पीने जाते हो, यू कैन सी दे हैव वेरी सिमिलर डिजाइन्स एवरीवेयर. ऐसे और भी बहुत सारे, दिस इज अ लिटिल हाई एंड काइंड ऑफ अ थिंग टू से दिस, बट ट्रेड डिजाइन जो होती है वो इसमें बहुत सारे ऐसे कैफेज या इसमें मिलता है आपको, वेयर यू गेट द लुक एंड फील व्हिच इज सेम अक्रॉस ऑल ब्रांचेस. तो वो भी उनका एक क्रिएटिविटी होता है. जैसे आई टेल यू, दिल्ली में देयर इज अ होटल व्हिच इज वेरी फेमस. इट इज सम केव्स है, उसका नाम शायद केव्स, यू कैन सर्च, ठीक है. उसमें जितने भी रूम्स है, द एंटायर स्ट्रक्चर इज बिल्ट लाइक अ केव. आपको लगेगा कि आप केव के अंदर जा रहे हैं. रूम्स इनसाइड द केव, इनसाइड जो है इट्स बिल्ट लाइक अ केव. फायर प्लेस है जैसे केव में होता है. यही अगर आप वो करोगे, बनाने की कोशिश करोगे, वो जो ओनर है, दे आर गोइंग टू सू यू इन द कोर्ट ऑफ लॉ, क्योंकि ये उनका डिस्टिंक्ट फीचर है, ये उनका डिजाइन. इंटेलेक्ट है ना, क्रिएटिविटी है ना. घर में केव बना के उसको एज ए होटल, क्रिएटिविटी है, बट दैट इज नॉट कॉपीराइट, दैट इज नॉट टू डू विद परफॉर्मेंस. ठीक है, ट्रेडमार्क हो गया, डिजाइन हो गया. जीआई, शांति निकेतन का ये जो काथा स्टिच है, इट्स इंडिजिनस हियर, यही होता है. यहां से लोग ले लेके पूरे हर जगह कर रहे हैं और अपना प्रोडक्ट बोल के बेच रहे हैं. रिसेंटली प्राडा कंपनी का नाम तो सुना होगा, प्राडा. कोल्हापुरी जो स्टाइल ऑफ द चप्पल है, उन्होंने उसको अपने प्राडा का फैशन वीक में दे वोर इट एंड दे सेड ये भाई हमारा है. सो ये मिसरिप्रेजेंट हो गया ना. आपका क्रिएटिविटी है, प्राडा नहीं ना, आपने किसी से चोरी किया ना. दैट इज द प्रोटेक्शन ऑफ डिजाइन, सॉरी जीआई. कि कोल्हापुर का चप्पल कोल्हापुरी चप्पल. सिमिलरली शांति निकेतन का है, ये आप एज अ डिजाइनर यू कैन नॉट से कि मैंने अपना बनाया, व्हिच इज एग्जैक्टली शांति निकेतन काथा स्टिच. व्हाई? बिकॉज वी आर प्रोटेक्टिंग द राइट्स ऑफ द पीपल whose product it is. जो जनरेशन से lineage से दे आर डूइंग दिस. नहीं तो क्या करेंगे, which is exactly what US had done long time back. बासमती राइस का सीड्स यहां से ले गए, वहां जाके दे प्रोड्यूस बासमती राइस एंड सेड बॉस इंडिया यू हैव टू बाय फ्रॉम अस नाउ, यू कैन प्रोड्यूस, क्योंकि ये तो हमारा है. भाई बासमती राइस यूएस कभी सुना है? बट दैट्स एग्जैक्टली व्हाट दे डिड. They did the same with turmeric as well. So now you see the problem, because these people, they are unaware of the law, so they get exploited. So the law was brought in to protect their rights. So creativity is there in all of this that we are discussing. But we as performers, we are not concerned with trademark. We are not concerned with the design. We are not concerned with the GI. We are not even concerned with patent, but we are concerned with copyright. तो copyright में जाने से पहले मैं पेटेंट पे बात थोड़ा सा करना चाहती हूँ बिकॉज बहुत ज्यादा इसमें मिसकंसेप्शन है. पेटेंट इज टू डू विद इन्वेंशन. आप कोरियोग्राफी इन्वेंट नहीं करते हो, आप कोरियोग्राफी बनाते हो. एंड कोरियोग्राफी का कोई इंडस्ट्रियल एप्लीकेशन नहीं है. देयर इज नो इंडस्ट्रियल एप्लीकेशन ऑफ अ कोरियोग्राफी. Patent is for all scientific developments and innovations for which there is an industrial application. So a machine which can possibly do that, metallic testing at airports or in the libraries or wherever, that is a machine. Or let's say to produce at a speed of, I don't know, 1,000 or maybe lakhs per second newspapers को जब छापते हो, that is a machine. So जो first time उसको बनाएगा, that person can claim a patent. So novelty, inventive step and industrial application, ये चीज दिखाना पड़ता है for patent. पेटेंट में दो चीज होती है, प्रोसेस पेटेंट, प्रोडक्ट पेटेंट. प्रोडक्ट को आप पेटेंट करते हो या जो प्रोसेस आपने नया इन्वेंट किया उसको आप पेटेंट करते हो. क्रिएटिविटी एट वर्क है ना, बट साइंटिफिक क्रिएटिविटी पेटेंट. तो हम लोग साइंटिस्ट तो है नहीं, मैं तो बिल्कुल नहीं बन सकती थी. आई एम जीरो विथ मैथ्स एंड साइंस, तो मेरे ऊपर तो पेटेंट काम नहीं करेगा. नाउ आर वी ऑल ट्रू ऑन दिस दैट पेटेंट, नन ऑफ दीज दैट आई सेड वर्क when it comes to us performing artists. हाँ, अभी अगर let's say if you are having your own institution, performing arts institution, उसका एक आप लोगो बनाते हो, yes, it is your trademark. That is separate. ठीक है? But what we are now going to start is copyright. Copy plus right. Copyright. Any questions? Any concerns?
Ma'am, what is that about process and product? Can you please repeat
Yes.
that?
So product patent and process patent. So product patent is that you are patenting the final product. जैसे कि Xerox machine जो होती है, photocopy machine was produced by Xerox company. They patented it. That is product patent. Process patent is you have developed a new process of, let's say, making cheese. वो जो technology जो अंदर machine के अंदर काम करती है, that is process patent. That is process patent. Okay. So copy plus right is copyright. अब ये तो AI क्या छोड़ो, अभी हमारे स्टूडेंट्स के मतलब हमारे जमाने से या उसके पहले से ही कट कॉपी पेस्ट सबको पता ही था, है ना. कॉपी पेस्ट, मेरा काम सिलेक्ट और कंट्रोल C कंट्रोल V, प्रोजेक्ट जमा हो गया, ऐसे है ना. कैन यू डू दैट? अब यही मेरे से करो, मेरा कोई आर्टिकल से छापो तो क्यों, मुझे क्यों अच्छा लगेगा? छोड़ो. अभी तुमने कभी एक आर्टिकल लिखा जिंदगी में विद ऑल योर एफर्ट्स, योर फ्रेंड कॉपीज एंड पेस्ट इट, कैसा लगेगा? अच्छा लगेगा? नहीं ना. सो व्हाई विल सम ऑथर्स अलाउ यू टू डू दैट? कॉपी एंड पेस्ट. इट्स माय क्रिएटिविटी, isn't it? So copy plus write. Do I have a right to copy what I see? Do I have a right to copy what I have written, what I've read? Do I have a copy to sing what I have heard? Do I have a copy to do what I did in that photograph that I showed you? Do I have a right to copy? No. Because if you copy, then you are eating on someone's creativity. किसी और के काम पे आप ले रहे हो ना. एंड लॉकियन लेबर थ्योरी क्या बोलती है? जिसका लेबर उसका राइट. सो मेरा तो लेबर है, मेरा लेबर क्या है, मैंने कॉपी किया, पेस्ट किया, हो गया, और प्रिंटिंग किया, जमा कर दिया ना. दैट इज व्हाई प्लेजरिज्म इज अ कंसर्न. यूजीसी में सबको प्लेजरिज्म करते हैं. दिस इज व्हाई ethics, we began by talking about ethics. So all of intellectual property rights is to protect against unethical use of someone's creativity. So copyright is about creative work. creative work. Now, what is this work? What can be the different types of work under copyright? And that's exactly what you all have said. Copyright can exist in literary, dramatic, cinematographic, artistic work. फिल्म में कॉपीराइट होती है, परफॉर्मेंस में कॉपीराइट होता है, ड्रामा में कॉपीराइट होता है, म्यूजिक में कॉपीराइट होता है, म्यूजिक के लिरिक्स में कॉपीराइट होता है, स्क्रिप्ट में कॉपीराइट होता है, प्रॉप्स एंड सेट्स में कॉपीराइट होता है. ऑल ऑफ दिस इज कॉपीराइट. तो ये जो वर्क है इसका कोई ना कोई तो ऑथर होगा. There will be someone who will be the author of this work. Author of a literary work will be the one who has written it. Author of a literary work will be the one who has written it. This literary work could be an article, could be a book, could be a blog, could be your Facebook post, could be your commentary on something, could be anything that you write, that you simply write. Whether you publish or you don't publish, it is your copyright. If you publish, it is easier to prove that it is yours. If you have not published, it is a little difficult. But the moment you have written, it is your copyright. The notes that you are taking down is your copyright. Because you are doing the label, jiska label usi ka right. So only you and you have the right over your notes. So next time when your friends ask you notes de do, you can simply say, no, it's my copyright. I did that. I used to do that. No, I mean, jokes apart. Not really, but yes. Because it is your copyright. No one can copy. Okay? So literary work. Next is dramatic work. Drama. Drama ka script. Drama ka jo script hai, that is both a literary work as well as a creative work. So it is protected. Next is music. The lyrics. It's protected. Lyrics are protected because it is written. So it is literary works, it is protected. Plus the music that comes out of it is also protected. Because it's work, it is creativity. Now when you record this, singing ho raha hai ya dance is being performed, when you record this, are you an author? Are you an author when you're recording it?
No.
No. But you are recording it as a recordist. And there is something known as broadcaster's right, whereby you can broadcast it. Otherwise, दूरदर्शन में तो कभी performances ही नहीं होगी, AIR में तो कभी भी हमारा गाना सुनने को ही नहीं मिलेगा. That is for the purposes of disseminating your creative work. And so there is a protection which is special. So that is one kind of, you can say, as an exception. तो ये सब जो मैं बोल रही हूँ, ये आपको कहाँ मिलेगा? ये आपको मिलेगा in the Copyright Act of 1957. मैं आसानी से यहाँ दिखा सकती हूँ, but I want you all to get active. Take out, even the ones who are online, Copyright Act of 1957. सबके पास phones तो होगा? तुरंत please, let's get to work. 1957 Copyright Act. Because I feel you should know the law that you are referring, that we are referring to. तो ये जितना भी चीजें मैंने बताया, if you see, this is mentioned in section 2. Copyright Act सबको मिल गया? Yes, Copyright Act. Copyright.gov.in में ही मिल जाएगा. Copyright Office का ही, it's the PDF version is uploaded. No, section 2, chapter 1, section 2. This is from page number 2 itself, if you see. Page number 2, page number 3, जितने भी आपके डाउट्स हैं वो मैं क्लैरिफाई करूंगी, इसके बाद भी अगर आपको कुछ रेफर करना है, दिस इज वेयर यू विल गेट अ लॉट ऑफ, हाँ, नॉट जस्ट इंटरप्रिटेशन, सारे जितने भी डेफिनेशन है, यूसे आर्टिस्टिक वर्क, ऑथर, सब दिया हुआ है जो मैं अभी तक आप लोगों को बता रही थी। Come to why. Come to why. Chapter 1, Section 2, definition जहां लिखा हुआ है वहां पे देखो, आप नीचे आओ, why मिलेगा, why. इसको आप क्लियरली याद रख सकते हो, why are we doing copyright? So why में आपको मिलेगा work. Like that you can remember. Why tells you about all the works that are protected under the law of this country. So there, exactly what I have said, देखो आपको सब कुछ मिल जाएगा. Work includes literary, dramatic, musical, artistic. This artistic work, इसका भी definition ऊपर दिया हुआ है A में ही. Cinematographic film, sound recording. ठीक है? तो अभी everyone, did you get it? Did you read it? Work. ठीक है? तो ये समझ में आ गया कि कॉपीराइट का जो लॉ है ये वर्क पे काम करता है, because it tends to protect a work. ठीक है? These are the works which are protected. Now, who gets protected? I said author. Author gets protected. So let's go to the definition of author. D में है author. D. D में you see exactly जो मैंने अभी तक डिस्कस किया आप लोगों के साथ वही आपको मिलेगा. लिटरेरी के लिए कौन ऑथर है, म्यूजिकल के लिए कौन है, आर्टिस्टिक के लिए कौन है, फॉर फोटोग्राफ, सिनेमाटोग्राफिक फिल्म, लिटरेरी, ड्रामेटिक, म्यूजिकल, आर्टिस्टिक, सब कुछ के लिए ऑथर कौन है दिया हुआ है. बट इसका फंडा टू रिमेंबर वेरी क्लियरली फॉर यू ऑल इज दैट जिसका लेबर राइट उसी का. ठीक है? बट थिंग्स विल गेट कॉम्प्लिकेटेड एंड वेट फॉर इट. ब्रॉडकास्ट, उसके एग्जैक्टली नीचे ही डीडी में आपको ब्रॉडकास्ट भी मिल जाएगा. व्हाट इज ब्रॉडकास्ट? ब्रॉडकास्ट इज बाय द वे ऑफ डिसेमिनेशन, वायरलेस डिफ्यूजन, दिस दैट एवरीथिंग इज रिटन, but it's basically when it is getting disseminated to people. Your work is getting disseminated to people. Now if you want to know about, because of paucity of time I'm not going into every definition. You have definition of cinematographic film, which is in F. F for film and F for cinematographic film. What is it? All of that is mentioned. Artistic work is mentioned as well. Now, but I want you to refer to artistic work. So go to artistic work. C. Yes, C. Painting, sculpture, drawing, including diagram, map, chart, plan, photograph. Whether or not any such work possesses artistic quality, ये तो is subjective. But somebody has made it, it is artistic. Okay? Architecture and any other work of artistic craftsmanship. Artistic craftsmanship. That means artistic is not what we understand as performing artist. Can you note that? Can you see that? वर्क में जो भी बात हुआ है, लिटरेरी, ड्रामेटिक, जो भी, अभी कहीं पे भी आपको परफॉर्मिंग आर्टिस्ट का कुछ मिल रहा है? परफॉर्मिंग आर्टिस्ट, आर यू गेटिंग एनीथिंग टू डू विद परफॉर्मिंग आर्टिस्ट्स?
No.
No, right? Artistic is equal to basically artistic as in sculpture, painting, उसका बात हो रहा है ना. But तो फिर मैं यहाँ पे क्यों why am I talking about artistic work here? Copyright. That is because, as per law, we come within the conception of performers. Performers. तो आप परफॉर्मर का डेफिनेशन ढूंढते हैं. चलो, 2Q में मिलेगा परफॉर्मर. Performance, sorry, and 2QQ will be performer. ठीक है? So performance in relation to performer's right. So copyright के अंदर, within copyright, we have something known as performer's right, and that is exactly what we are concerned with. So performance in relation to performers' rights mean any visual or acoustic presentation made live by one or more performers. So performance is protected, and performance जो perform कर रहे हैं, they are performer. That's why they are protected under 2QQ. So 2QQ says performer includes actor, singer, musician, dancer, acrobat, juggler, conjurer, snake charmer, a person delivering a lecture, or any other person who makes a performance. So anything live that we are doing is performance. And that person who is doing it is a performer. So we as performers have a different status than that of other work and other authors. तो ये हमारे लिए जानना बहुत ही जरूरी है that we are not authors जो मैंने आपको पहले दिखाया. We are not that. Artistic work में हमारा work नहीं आता है. Our work and us, we come under a separate special category known as performers and performing and performance. Because, and now, ये मैं आप लोग एक काम करो, footnote पे जाओ. 2QQ का जो footnote है, third footnote, what is mentioned there? Subs करके कुछ लिखा हुआ है, subs dot है ना, right? और 3 में भी देखो 3 दोनों Q and QQ में. Actually P, Q and QQ तीनों में ही 3 दिया हुआ है ना. Subs means that substituted, which means this was an amendment. For law, wherever there has been an amendment, there will always be a footnote to state in which year it was inserted. Okay? Now this was inserted in the year 1995 and it was brought into effect, and you can see from when, 10th of May 1995. Why? Because earlier, the special ones, this was not even in the conception of the lawmakers. Copyright का जो history है, now going a little bit into the history, it comes from the Gutenberg press. France में, the French Revolution के time पे, it is when this press started, because the philosophy, the revolution जो हो रहा था French Revolution के time पे, we had to disseminate it. How do we disseminate? We print it. अभी भी होता है ना, pamphlets बेचते, देते हैं, right? That is how you gather people. That is how you spread information. So we needed something, a machine which will be printing in mass numbers. Otherwise, we had to earlier write posters. Handwritten posters had to be made. So with this press, that changed. It was a printing press. So that is how people got to know, oh wow, we can copy now. So we started copying each other's work. That is when, for the first time, something known as Statute of Anne came up. Statute of Anne, A-N-N-E, Statute of Anne, which for the first time prohibited such copying without permission of author. So you understand history was with regard to this kind of work, literary work, written work. So ये जो performance वाला work है, this was not even in the conception of the lawmakers. And that is why initially the law was only to protect authors who were writing books. While we were protecting what is being written, we also saw that the lyrics which are written are also written. So music got protected. Script is also written. So drama people got protected. So this is how everyone got protected. But we, the dancers or the performers, we don't have anything written, right? When we are doing a choreography on a particular song or a music, do we know? Do we write? We will first move our right hand, then the right leg, and then we go back. Do we write like that? We don't, right? So there was nothing written that we could protect. So what to protect? But I told you, intellectual property is to protect the intellect of the product as well as what is in your mind. Right? And that is why later on, in 1995, we see shift in the law. How did this shift come? This shift came because internationally, the organization which is responsible for protection of rights, intellectual property rights, is WIPO. That is WIPO, World Intellectual Property Rights Organization. WIPO. WIPO, you can say, is the boss for all things to do with IPR. So WIPO governs everything to do with whatever branches of IPR that I discussed with you. WIPO को ये बताया गया that this is what we are seeing. This is a problem. This problem was felt and was brought before WIPO. And so WIPO said, well, we need to do something. And so they come up with a treaty known as WPPT. WPPT. WIPO, Performers and Phonograms Treaty. WIPO, Performers and Phonograms Treaty, where for the first time they recognized our existence as performing artists. That made us in India amend the Copyright Act of 1957 and bring in this new edition. Is this now clear to everyone as to? Yes, please.
Just a clarification.
Yes.
So, I don't need the microphone. Okay. So you're saying that every performance is copyrighted. What do you think?
No, that I have not yet come to that. As per the law, performance which is live or acoustic is protected.
So, I will perform a particular composition which has been composed. Suppose it's notated by X, Y, Z, whoever. And then, of course, I say I'm singing this composition, and then what I do with that composition is improvisation, right? And then is that copyrighted? Because the same performance can be like
Absolutely
recorded, and there can be somebody else who can actually verbatim repeat it, but then it becomes his or her own property because
correct. Absolutely, that what you just said. One's property. That's what this performance is all about. And that's where I'll exactly come to. Yes. Each performance is protected. And that's exactly what I was coming to as the next one. That is, what I'm constantly saying is that we as performers got protected. We got this recognition of performance. So now, this performer is the one who is performing live. I told you, you just read the definition. But can there be a different person who actually made it? Someone who wrote it? Because when I was telling you about the fact that law from 1957 protected the creators, the ones who created. So the ones who wrote the music, they were protected, I told you, because lyrics were made. So that person, for the first time when the person wrote it, it became that person's copyright property. So उस person को तो 1957 से ही protection था. So protection किसको नहीं था? जो perform कर रहे हैं उनके पास वो protection नहीं था. So this brings in the difference between creator and performer. Choreography could be of person X, and that could be performed by 100 people. Shama Davar could be a choreographer, and there are 1,000 dancers for performing on his choreography. So the performers are what we're talking about here. And the creators are the authors that I already told you. So ye difference, did you understand? Ki what I am telling you is live performance or acoustic performance. When I'm performing on the stage or anywhere, that is performers' rights. And that's why you see in 2QQ, it's very specific. 2Q, it says performance in relation to performer's right. So from here, we will kind of jump a little bit to understand topic को समझ आया, right क्या है? What are the rights that we get as a result of being an author? What are the rights? आप लोगों के हिसाब से क्या rights आपको मिलना चाहिए? If you have written something, क्या चाहिए rights? If you have choreographed something, what do you think should be the rights available to you? What are the rights you think you deserve? नहीं चाहिए किसी को rights, कभी बनाओ फिर उसके बाद अगर ले तो लगेगा क्यों लिया?
If that is used for commercial purpose, then loyalty.
Yes, very important. Somebody using it to get money, commercial benefit. Somebody using your property to get money by saying that this is mine. Actually, somebody else's property. So first right is no commercial exploitation. First right is no commercial exploitation. Second right, own reproduction only with permission. Reproduction meaning once again doing it or publishing it only with permission. Name to be taken, credits to be given. You cannot copy. You cannot disseminate it. You cannot claim it to be yours. You cannot, in case of written word, you cannot copy and you cannot distribute it. These are the basic rights that you get as an author. So author's rights are also mentioned in this statute. This is chapter 3, Copyright Act of 1957. Chapter 3 onwards, it tells you what are the copyrights? What are the rights that you have against copy? Section 13 tells you what are the works in which copyright exists. And that I've already discussed, right? I've already told you what are the things on which there is copyright. Now, come to section 14, which is really the soul of the Copyright Act. It tells you the meaning of copyright. Section 14. Copyright means the exclusive right, and that's the very reason why the copyright law exists. Copyright means the exclusive right to do. That means on his, her, or their own, or authorize. That is permission. Authorize the doing of all those that you see in clauses A onwards. So, exclusive right. I have written a book. I have the exclusive right. I want to copy. I want to publish again. I want to throw them. I want to do whatever I want to do with it. Or I can ask somebody else to do all that I can myself do. So I can myself produce it. I can ask somebody else to do it. And this again, I'll come to it, how that happens. But you see, what are the exclusive rights you have? And what specific, what are the rights that you have is also mentioned. Literally a dramatic musical work, not being a computer work, what are the exclusive rights? Reproduce,
issue copies, perform in public, make a cinematographic film out of it, translation, adaptation, all of that. In case of computer program, somebody was mentioning programming. Yes, computer programming, coding is also copyrighted. So what can you do with that? In case of an artistic work, that is your C, artistic work, you see, that is sculpture, let's say, storing, depiction in 3 dimensions of a 2-dimensional work, depiction in 2 dimensions of a 3-dimensional work, communicate to public, all of this. So now you see, all that I have been telling you all, everything is protected. And it is protected as an exclusive right. But again, मैंने क्या बोला है? We as performers, we are separate, we are special. We are indeed special. Artists are always very, very special. So we need special protection. यहाँ पे कहीं पे वापस can you see? हमारे लिए कुछ है law यहाँ पे? नहीं ना? हाँ, if I am the one who has made up music, I have the one, we have written a song. So I am anyway protected as the one who has written something. Right? But as a performer, no. This is why we have to go to sections 37, 38, and 38A of the Copyright Act. Just scroll down and let's go to 37, 38, and 38A. (37) broadcasters' right, 38 performers' rights, 38A and 38B exclusive rights of performers and moral rights of performers. Okay, तो पहले 38 पे आते हैं performers' rights. So again you will see a footnote there, and उस footnote में वही मिलेगा which you have earlier seen. 1995 के amendment के through you see. Performers right, then 38A, 38B, दोनों हैं, ठीक है? So performers rights, where any performer appears or engages in any performance, he shall have a special right. मैंने बोला ना हम लोग special है, we are special. हर जगह special लिखा हुआ है इसीलिए. Special right to be known as the performer's rights in relation to such performance. The performer's right shall subsist till 50 years from the beginning of the calendar year next, following the year in which the performance is made. तो अब ये दूसरा चीज आ जाता है कि कब तक exist करता है. Just leave that out for now because I'll discuss it later. But जो subsection 1 है, just read that and see that performers have a special right known as performers' rights. So what are these rights? वहाँ पे we read in 14 that copyright is exclusive right. So performer का भी exclusive right होगा. 38A provides for it. 38A tells you exclusive rights of performer. Now just read it. I'm giving you a minute. Please read it in silence and see that what it is for you to be known as a performer and what are the laws that you have. So just read 38A. Exclusive right of performers. This every performer should be aware of. And this comes directly from the international law on copyright, WPPT. You just read just the first one, that is subsection 1. From clause 2, don't read because I'll have to explain. So exclusive rights mean that you as a performer exclusively have these rights. It might seem to be very ambitious, but well, the law has provided for it already. It is not ambitious anymore. Law has already provided for it. Now, along with exclusive rights, you will see in 38B, there is something known as moral rights. Moral rights of the performer. So exclusive right is about these reproduction, this, that, all of that. Moral मतलब क्या होता है? You are a performer. Moral भी तो कुछ होनी चाहिए. Is it only about your right to be able to see that no one copies, reproduction? Is that it? तो कुछ और भी चाहिए. Morally भी तो there's something. मेरा नाम खराब नहीं होना चाहिए. अभी डीप फेक के जमाने में मेरा एक परफॉर्मेंस को लेके उसको अगर कंप्लीटली न्यूड करके यूट्यूब में डाल देता है, मॉरल नहीं है ना ये सारी चीजें. इट्स अनएथिकल. मेरे परफॉर्मेंस के पीछे में कुछ गाना डाल दिया, अश्लील कुछ गाना, मेरा नाम को कुछ और कर दिया. It's not moral. So the law also envisages of these, that as a performer you have certain moral rights as well. It's not just about your exclusive rights. And so the moral rights are more inclined towards protecting identity of the performer and to see that there is no damage to that performer. परफॉर्मेंस का नाम ही नहीं लेते हो आप, वीडियो बना रहे हो, परफॉर्मेंस का क्रेडिट ही नहीं लेता है. That's immoral. You are in violation of section 38A, 38B of the Copyright Act. किसी को पता नहीं होता तो कोई कुछ बोलता ही नहीं. You deserve to be recognized as a performer. And the problem in India is that performing artist community has always been on that side where they feel that an opportunity is huge. एक opportunity दे दीजिए बस. You never know how much that organizer is actually earning by giving you that stage. And I'm being very, very candid about it. And because I see the world from both the sides, and I deal with a true performing arts troupe, and I deal with all these maddening organizers, this is the reality. And I have seen this industry since I say that I have been born into this industry. So this industry is as naked as it can be in front of me. And I have no shame, which is why we have an initiative called unmute.help, which is kind of three people from three different generations came together to make this initiative. And there's a platform website also of this called unmute.help, where we talk about this. So that's the bare truth, but let's know the law. So these are the moral rights that you have. Now this moral right concept came from a case, okay, which was not a performer's case. It was a case of an artist, very famous artist, Amarnath Sehgal. Amarnath Sehgal was a sculpturist, and on Amarnath Sehgal's work, mural, he was asked to make a mural for the government of India for a particular office, at the hall, entrance hall of it, it will be displayed. It was displayed for several years, and then when they were doing a renovation of it, they simply took out the mural and they threw it inside the storeroom. Amarnath Sehgal did not know about it. Suddenly one day when he goes to the office and he says, "Oh, it's been renovated, so where is my work?" So they informed that, "So it's in the storeroom." What? My work, which is, I have sculpted this and I have done this painting, it's in the storeroom. You might not need it, but it's my work. This is just reputation. You are undermining my creativity. You are insulting me. That's what he said. And he moved the courts in India. So much so that the Supreme Court finally said that yes, exclusive right is something, Maybe exclusive right of that person has not been damaged, has not been infringed. No one has copied it, no one has reproduced it. But the moral right has been tarnished. So that is where the concept of moral rights of every author comes. And that got supplanted into moral rights of performers as well. Okay? Yes, please.
Here in 38A,
Yes.
the fourth point says that selling or giving it to on commercial rental or auction for sale or for commercial rental any copy of the record.
Recording, yes.
तो ऐसा होता है अगर जैसे मैं कोई रविंद्र संगीत को रिकॉर्ड करके कवर करके उसको यूट्यूब पे अपलोड करता हूँ तो फिर वहाँ पर एक कॉपीराइट क्लेम आ जाता है वो मुझे वहाँ से अर्न करने नहीं देगा
Now, so see again, one thing that we have to be we have to understand that the copyright law did not envisage of the world that we are in today, which is why बहुत ज़्यादा ये प्रॉब्लम अभी भी हो रहा है. खुद का ही किसी का गाना कोई डाल रहा है उसको कॉपीराइट हिट मिल रहा है, बहुत बार होता है. And this is an ongoing process, which is why YouTube के साथ, Facebook, Meta के साथ ये भी season process. ये हमारा भी एक प्रोडक्शन का ऐसा हुआ था कि somebody else was taking it, so we said this is ours, you see, take down notice भेजो कि take down करने के लिए. तो YouTube is asking how do we know it is your work? चलो अभी उसको भेजते रहो, उसको भेजते रहो, उसको भेजते रहो. But that's how the law changes, that's how things become better. But that is a problem that is happening. But yes, you have to show. So again, there is a process in which you do where you have to write to YouTube, saying that yes, this is the Rabindra Sangeet, but I am who performed this, I am the one who sung this. As per my law in India, it is protected like this. And so this is my work. Yes, of course, because you are performing it. That is why I'm saying performance ka alag right hai, we are special. We have a separate right.
So I think according to YouTube, it is a self-plagiarism, like myself.
Yes, because another problem is the one who uploads first.
Okay.
Usually uska matlab automatically ho jata hai. YouTube is also working on it, but it's very complicated. You see, it's very complicated even for YouTube. इसीलिए मैं खुद परेशान हो गई कि 3 बार मैंने भेजा. They're like, you send the script of the production. अब script को पूरा करो. अब script भेजेंगे तो ये टेगोर का डांस ड्रामा है तो बोलेंगे कि ये तो टेगोर का है. So it's very difficult. And again, it's very difficult for India. Because in India, we work a lot with traditional work as well. It's a little different when you work with opera. Because it's very, somebody has created it. Now again, let's see if it is to do with Shakespeare's, one of Shakespeare's work. But so again, that how you have to, in a sense, you have to show that whether adaptation or whether you have been inspired from the work, how you have done it, how it is your work. Now the problem I understand is it is not asked to prove. This is how law and performing artists never come together. Right? Let me perform. अब मुझे परफॉर्म भी करना है, बनाना भी है, आपको दिखाना भी है कि मेरा है, छोड़ो भाई, I will, it's fine. But the situation is changing now because a lot of artists are earning through online platform. People are actually now getting into the online space. I do watch a lot of artists, I mean, more to do with dance, that they are creating their own music, they are doing productions absolutely online. So usme issues have now started coming. So that's why I say that this is the reality. This is an issue that we are facing in India at the moment, and we are all working towards it. And that's why we need participation of everyone. जब ये हर जगह से जाएगा to YouTube, then only YouTube will be able to see, okay, we have to change our policy like this. Okay, so now moving forward, because I thought of discussing tons of things, but okay, let's see. So I think you've understood what are the different types, kind of work, and who are the authors, and the different rights that you have as an author. As an author, what are the different rights that you have?
Excuse me, ma'am. Can
Yes.
I ask a question?
Please, sure.
Ma'am, I wanted to understand, like someone gave me a platform to perform and I perform there. So it will be the organizer's right or my right as
A performer. As a performer, you are the performer. It's your right. It's simple.
and if it's a group performance,
It's
so
your right. Now I'll tell you where the catch is, and that's where I have to come to next. Without that, you will not understand where we go wrong and where we fall into a trap. Yes, your question.
Ma'am, my question is something similar like that. If my work is sponsored by an organization.
Yes. Got it. I'm coming to that only. I knew. That is what will be the next question. What if my work is sponsored? What if I'm doing as a part of somebody else's work? What if all these, right? So what did I tell you? That exclusive right is yours. Now, exclusive right of yours includes your right to give permission to someone to do something with it. So, if I give license to someone, that someone can publish my book, can perform again, can do whatever and how much soever I tell that person that you can do with my work. Or I can get into a contract. I am giving consent. You record it and you send it. So, yes. So, either I'm licensing it through an agreement, that is contract for license, contract of license. And I am telling what are the things you are allowed to do. That is within my exclusive right. But I have written a book. Now can I disseminate the book everywhere? वो जा जाके सबको मैं करूँ क्या अपने पैसा खर्चा करके पब्लिश करूँ फिर जा जाके बेचूं बुक फेयर में कहाँ क्या हो रहा है नहीं ना but if I don't give that permission to someone to a publisher they cannot publish my book they cannot do it so I agree to it that is consent I'm giving this is through licensing same thing we do as performers as well. Sadly, in India, performing artists के लिए contract कुछ भी नहीं होता. Very few organizations do it. Government के हर एक organization. Yes.
Ma'am, when we record for Akashvani, they
do have a contract.
Yes.
Yes, that's what I'm saying. Only government places they do it. And some private places also they do it. It will be a thick document which with a lot of things which we never read. Which we never read. Just like Amazon से order करना है भाई कुछ भी बोले I need it. Click, click, click. But we don't know what we end up clicking. So this is how you give some of your exclusive rights to somebody else. That is permitted in law. So once you have done that, then you cannot sit back, cry and crib. मेरा तो ले लिया, मेरा क्या होगा, मेरे साथ ये तो चला गया, मेरा था. Because you have yourself given. Okay, so that is through something known as contract of licensing. There is something known as assignment. Assignment, again, it's mentioned in the law. I'm not going into it. It's a little technical, but just know this. Assignment is where virtually that other person जिसको आप assign करते हो वो ही author बन जाता है. So usually it is done for the legal heirs. The parents doing it for the giving it assigned to the son or the daughter, daughter-in-law, son-in-law, like that. That you will ensure, you will keep profits, you will speak to publishers. कुछ मतलब वो virtually author ही बन जाता है. That is assignment. But licensing में only some rights you can give, not all. And for every kind of copyrighted work, this exists. This assignment and licensing this exists. So, to answer your question, that when you are going performing, the organizer, only and only when the organizer signs a contract, The organizers, the video recording of that performance of yours will be the work and property of the organizer. Otherwise, no. But let me also tell you the reality. ऐसे करोगे तो opportunity नहीं मिलेगा, performance करने को नहीं मिलेगा. हाँ.
अगर कोई कुछ बनाता है कुछ परफॉर्मेंस हो सकता है और ऐसा बोल देता है कि ये कोई भी परफॉर्म नहीं कर पाए,
हो सकता है.
तो फिर क्या कोई उसको परफॉर्म एज ए परफॉर्मर परफॉर्म कर सकता है?
Interesting question. So this is the difference between the one who is making it and the one who is performing it. Choreographer के पास choreographic rights रहता है. Performer only has the rights as regards the performance. Because जिसका labor उसी का right, तो labor तो performance में है, उसको create करने में तो नहीं है. So creativity का जो right है, that will be with the dramatist or with the film director or the one who has written the script. You are only performing, so you only have the performing rights. But if you are co-creating it, if you are the co-author, then you will have the same rights that of the author. Or if you have an agreement with the author, भाई आपका 10% rights, मेरा 30% right, या 50-50, या 70-30, then that. Challenge is when you are doing a choreography on behalf of an organization or a dance institution like that, no? It is the copyright either of yours or the organizer, depends on the contract. सारे गामा और क्या नच बलिए जो भी सारे all these reality shows, performer तो जो perform कर रहे, choreographic rights तो जो choreograph कर रहे, but entirety of the recording is of either Z or this or that, whoever it is. How is it written? It's in the contract. So you should always read the contract before signing to know what are your rights. But yes, as a choreographer, no one can say that it is the choreography of X institution. Credit usko dena hi padega. It is possible that you will not be able to perform that again if that contract says ye.
Literally, that was the ABCD, anybody can dance.
हाँ, anybody can.
Prabhudeva,
हाँ.
all the dance steps was the copyright protected.
Now, so again, so you cannot really protect any step. As of now, we haven't gone there. You cannot really protect a step, but you can protect a choreography. Yes, you can always protect a choreography. That is why I said that whether now I'll come last part of my discussion before I go into a couple of case laws will be really about how do we protect it. So how do we protect it? Right? What we protect, I think we have all understood. What we protect. Now the case of dancers especially and singers is the problem that as of now the law is unclear really as to how much and how which not to protect for. Because there are a lot of things which are in the public domain. So public domain where whatever is there, we cannot have copyright over it. Because वो तो public domain में है. जैसे टैगोर का कोई भी writing, टैगोर का now so I come to that part also. हाँ. Folk, if it's there in the public domain, it is no one's property.
Like the classical music.
Classical music, yes, classical music. I'll give you a case, very recent case. Guru Shishya Parampara तो I should not get going only. उसमें तो इतना सादा questions आता रहता है. But ठीक है चलो. Let me see how much I can. Yes, that. Then
yesterday, day after yesterday.
2 days back. 2 days back. Yes, yes. Also, Ilyaraja's case also. Very sad, but that's the reality. Okay, but before going in there, 2 things. That is, how do you protect copyright? How do you protect? ये तो बता दें ये right है बोलो. How do you protect? You do not need to protect it as such because when you have written or you have made it, it is your copyright. But as I said, problem is आज के जमाने में कॉपी बहुत जल्दी होता है, बहुत फास्ट होता है, right? So that is why it's always a good idea to protect it. How do you protect it? There's something known as the copyright society. Now copyright society, हर एक जितने भी वर्क मैंने बोला सबका अलग अलग copyright society है. Every work has its own copyright society. Artistic collective, singers collective, like that. It's there. Yes, that is also I think registered as a copyright. It is registered as a copyright society. So copyright society basically is that safe space, you can say, I have to explain it as simply as possible. Where you go, you submit and you say, this is my work. Please protect it. Okay? So you become a part of the copyright society. Copyright society exists to protect you. But again, for dancers, it's a little difficult because we don't have a specific copyright society as such. And so, howsoever, whether you have a copyright society or not, you can always file an application before the Copyright Office. All of these bodies that I'm saying are present in the law itself. You can read through the law and you will see. So these copyright offices are where there's a form you fill up. Forms are available now online also. You can download the forms. You have to fill up. It's very lengthy. You have to provide for all the details that's needed. And then submit it. They will follow a process and you register it under your name. With regard to a book or article, usually this is not needed because the publisher themselves, they publish it, they display it, and you do get into a contract with them saying that it is my copy. So usually, but howsoever, it doesn't stop you from registering your book or your article with the Copyright Office. You can do it, but it's not necessary. But for choreographies, such music that you're creating, it's advisable to do it, to get it registered, so that nobody else can copy. And in today's time, this has just become a little more required. Pehle ye nahi tha. That's why. So,
digital timestamp, if I upload anything like my work on the YouTube or
exactly, you can do it.
social media.
Yes, that's what I'm saying.
With the digital time frame.
Absolutely. That's what. But difficulty is that if someone does it on the same day, problem is Guru Shishya Parampara. No, it's not a problem. It's what we really, in India, that is what we boast about. So I am always in a very difficult position when I have to comment on this. It's both emotional and it's very difficult for me to comment on this. Now, why does it's a problem? Because two people learning the same thing. What if they're performing the same on the same day? Right? So, but both of them are protected as performers. The one who has taught them, they are protected as the creator. Right? So this now I think you can understand the nuances of different kinds of protection that you have. As a performer, you cannot claim the protection that the author, that the creator has. You cannot become the creator, but you do have a performing right. And a right to be protected against distortion and all that. It can be both. That is why it's coming under performers' rights.
What I'm doing is not a replica or a carbon copy of my group.
Exactly.
If I feel like that, then you would not have a sort of a lineage and
absolutely. Yes.
So
this is the difficulty. That's why I say that it's very difficult. Even as dancers also, we can do something also with our expressions, let's say. Right?
Dance, you have a bit more choreographic.
That's again becomes a problem. That's what I'm saying. So again, for performing art, this is what I have argued in a paper of mine as well, and I have always debated this with a lot of IPR scholars that can we at all have a strict format for such performers and creators? It's very difficult. How much of it do you protect? Uday Shankar's style of dance, Uday Shankar is a very famous pose. Yes, this pose. Now, if I am using a different context, am I then violating his copyright? Right? So this is very difficult. So we do not know what it is going to be like, but that is why you remember I said that I began by saying law is also what the judges also say. So that's why we come to a few case laws. Recently, the Delhi High Court, last year, the Delhi High Court said, this was Justice Pratibha saying, that even if the ragas and the talas, everything is of your guru, but you have done it, this is your protection. You can claim copyright. This is in 2025, I think November or so. I think that, yes. If you want, I can share the link also, but you can always find it. I'll just tell you how it was reported, so it's easier for you to find out. It says, musical works based on Hindustani classical music can be original, even though belonging to same genre, raga or tal. How you perform it, that can be your creativity and you get protected. So the law doesn't tell you anything of that, but the judge's law is helping you to decode these nuances.
So in that case, am I being protected as a performer or as a creator?
Yes. So how far as a creator depends on how much of your creativity. And now the problem is lyrics, the lyricist will get. The musical recording, the composition, whatever is written is protected by the guru or whoever has created, not just the guru. The how it will sound is also through the lyrics it's done. So your stake in this becomes at the moment with the law, it's more as a performer than as a creator. As of now, we haven't gone into the nuances of that creativity. How do you find out that creativity? It's very difficult, but that is what possibly the law is going towards. That is to protect you as a creator, not just as a performer. And so, even though the law does not, I think the statute, Copyright Act does not give you that protection, it does not mean that it does not exist. The new laws are actually, or the judges are actually working in making it work. And this will happen only when we as artists engage more. To quote another example, that is Vempati Chinnasatyam's son. So Vempati Chinnasatya, I think all of us know, Padma Bhushan Vempati Chinnasatya, Kuchipudi dancer, dance artist, he is no longer. His son, Vempati Ravi Shankar, he is also no longer. He was a dancer plus a music director, music composer. And he composed lot of music on which Vempati Chinnasatyam's choreographies exist. And Guru Shishya Parampara, so they have been teaching, the Kuchipudi Art Academy has been teaching for so long, all that. After the death of Vempati Ravi Shankar, this was, I think, 2 years back, for the first time, this was really a first time kind of a copyright case being filed by a dancer or someone from that fraternity of performing artists. The wife of Vempati Ravi Shankar, the music composer, approaches the court to say that I want is in the court's intervention, to protect the music recording of all my husband's work. Otherwise, what is happening is unauthorized use. I am simply taking the music and I perform. Maybe I'm just giving credit, but they are commercially using it. It is my husband's compositions. I should earn, not them. This actually shook the entire artistic community because we believe in the Guru Shishya Parampara. where it's a very organic thing that the guru will send the shishya for performance here, there, this, that. Until then, we did not see a strict application of the copyright law in this manner in classical dance space. Now, in this, the problem was that a lot of artists were performing on their songs which they were given to them because they were shishyas. So what happens to their life? What happens to their career? What if they have to be asked to pay a lot of money to buy those music tracks? But as the law is, and when a law is clear and stated, we cannot deviate. So protection was given to all the compositions of Empathy Ravishankar. And without their permission, they cannot perform. So now you see how one judgment of the Delhi High Court, that I said, is helping to clear the grey area and trying to give you more protection. And on the other, the law can be detrimental to more young performers. But you certainly need a protection in order to sustain creativity. And the sustaining creativity comes with another ancillary aspect to it, which is the public domain. So copyright, it does not mean that you have it forever and ever and ever. Copyright for every work is for a limited period of time. Because after that, if it does not come to the public domain, creativity of humans will stop. So the idea is to keep nourishing and nurturing that cycle of creativity. So, for example, authors, as in literary work, lifetime plus 100 years. For broadcasters' rights, 25 years. For performers' rights, 50 years. So the law is very specific on the time limit. After that, it comes to the public domain. And then we cannot claim that this is our ownership, our property. So I think we're almost coming to the close of it. I just wanted to highlight one thing here, and that is section 52, which hopefully will solve a lot of problems that some of you might have, questions that some of you might have. Section 52 is an exception to using all copyrighted work without any permission. It is the fair use provision. Fair use. There's a long list which tells you that even if you have not taken permission, but you have used it in these manner as mentioned under section 52, then those are protected by law and you are not infringing the right of a copyright holder. First and foremost is educational purposes. So if I am using a video or something, or even if I'm performing something and showing it here, I am not in violation of any copyright law because I am using it for educational purposes. In that same manner, if you're using it for sensitization purposes, let's say you're using a movie or documentary and you are using it for sensitization, gender sensitization. Let's say it's a movie on domestic violence. So using that movie without the permission of the authors, but it is for purposes of dissemination. Okay. So like that is a long, long list. But I'll tell you a very funny case, which happened a couple of years ago. And especially in northern India, you see that a lot of music is used in wedding. Bharat mein use hota hai. Then DJ. These days we have started having a DJ thing even in the eastern part of the country. But it's mostly in north that you see it very much prevalent, right? Bharat mein the songs are being used and DJ is performing. Then abhi to entry mein, exit mein, isme, usme. हजार सारी चीजों में तो होता है ना, ऊपर से लटकते हुए, आकाश में उड़ते हुए, एंड फैंटेसाइजिंग ऑलमोस्ट व्हाट ऑल, है ना. So one event management company who had a DJ playing was stopped. Why? Saying that you haven't taken permission from the ones who have made it. Now, very important, Section 63 of the Copyright Act tells you that this is a punishable offense and this is cognizable in nature and is non-bailable, which means you can be arrested. You can be arrested. So all the more, the police gets involved to tell you that, stop all this. We're not going to allow this. And police being police does it. And this harassment was something which was being seen. So, the Delhi High Court says that if you are using it, if you are using DJ and all such songs in weddings, it is covered under Section 52ZA, Clause ZA, which tells you that if you are using music for wedding or any other religious ceremonies and such purposes, it is fair use. And so it will not be coming within copyright. And hence, use हो ही रहा है, use और होगा, होता ही रहता है ना? For wedding, just a wedding, these days even for birthday parties and childbirth, सब में तो use होता है. It is protected under the ceremonies concept. ठीक है?
But एक query, ये जो प्रोग्राम शादी में हो रहा है जिसमें कोई भी गाना बज रहा है जो कॉपीराइट प्रोटेक्टेड है, वहां पे तो अलाउ है, लेकिन जब किसी का वीडियो रिकॉर्डिंग करके कोई यूट्यूब पे डालता है,
हाँ, वो तो रिकॉर्डिंग के राइट पे आ गया,
तो वो अलाउ नहीं है.
Nah, that is protected. That's what the court actually the court did not finally come to a judgment on this. The reason being that the parties went on mediation. Okay. But yes, if you're recording it, so you're recording a performance. So the one who is recording it, that person has the broadcaster's right. Now, when it is being performed, performer's rights है.
And the music जो
use हो रहा है, that is for religious purpose. That is, you can say like an ambiguity there.
Okay.
Because that music is being used. Now, the thing is, if this video you are putting up and you're commercially earning out of it,
yes,
then it will be a problem.
That's the problem.
Then it will be a problem. But as of now, we haven't seen a case like that. That's what I'm saying. Law is not that is only there in the Copyright Act. Law will also be what we as artists also want for ourselves. Had it not been the Delhi High Court, which had been invoked, and Justice Pratibha Singh wouldn't have said about Hindustani classical music, हमें कभी पता ही नहीं होता that yes, we can ask for rights even as a creator, whether we are doing this, we are in the same genre, same raga or not. So that's why I began by asking this question as to what is law. Because, and let me be very honest, Copyright Act at the moment does not envisage the entire world of performance and artists. It cannot, it doesn't. Because we have not had so many interventions. So it is our onus that whenever there is a problem, we do something about it. And that's how laws become better. That's how laws become better. Now, I think I am almost up with my time. I think we started with 5 minutes, 7 minutes late. So I think I do have time to tell you about 2-3 things that I intended to. That is about AI. Because AI is the big giant in the room right now. So do you all know that recently recently in 2024, A.R. Rahman was criticized for having used voices of 2 artists in a movie called Lal Salam from south of India. And I think the 2 artists were Bamba Bakya and Shahul Hamid. Right? So their voices were used, who are dead, who are no longer there, their voices were used to create music by A.R. Rahman for this movie. And recently, I mean, I think it has been there in the reels a lot, right? All the ones who are dead singers, their voices are being used. तो इसमें क्या? What is it? Copyright है क्या नहीं है? क्या है? What do you think it should be? Because you had said, right? Copyright over voice. Now having hopefully understood what copyright is, copyright over voice हो सकता है क्या? It's what you're born with, na? So A.R. Rahman was criticized and all that happened. A.R. Rahman said that, I have taken permission and I have given compensation, that is, I have given money to the families of all of these two artists whose voices I have used to create music. And his idea of using AI to get their voice into the music that he was creating, he said, was to keep them alive and their lineage alive. Now, how do you see it is really a question of perspective. But what comes in here is moral rights of people who have been creating, and thereby another very niche area is slowly coming in, which I think I should tell you all, is about personality rights. Personality rights. A lot of actors and actresses and celebrities from Bollywood, they have been going to the court asking for their protection of their personality rights. Personality rights come directly from moral rights. And that is why it is tending to crawl into the domain of copyright. This was the same kind of argument being taken by Vempati Ravishankar's wife, that the morality of my husband's work is being taken away. And after a lot of debate, lot of things, there's a very famous judgment on privacy. Puttaswamy, this is Puttaswamy case, Puttaswamy judgment, which is more famous known as the Aadhaar judgment, where right to privacy was discussed. And privacy directly connects to moral rights. And that is why, whether moral rights and privacy, what will happen there was the question. But privacy and personality rights, as of now, what the courts have stated, is that it survives till you survive. It dies after you are dead. But at the same, and so what its repercussions in copyright for performing artists, because their music will stay even after they are gone. Their dance will stay even after they are gone. And these are questions that are coming up. And there is no specific answer that I have, or possibly the law has at the moment to give to you. But remember that this is also something which is slowly coming up, because as I always remember Sharad Kelkar saying this, that if my voice is taken, then tomorrow I will not have a job. They can simply use my voice and create music. Yes, sir.
Point out, like recently, yesterday or somewhere I read that Shatrughan Sinha has gone to Bombay court and he used the dialogue what he has used in the movie, that is Khamosh. So what is your take on that?
My take. When it comes to copyright,
ये हमारी मम्मी है
कितना देना?
अभी इनके भतीजे का रिश्ता करवाया ना आदेश की लड़की का हाँ
We are not able to hear.
So that was a Tariq pe Tariq. It is a very famous popular dialogue. So now that is what I feel. I mean, if you so stringently try to bind, even though I work, my life more or less revolves around law, I always say law is not the answer for it. It cannot be, because we are human beings. Until and unless we are impinging on the right of someone, I don't think so there is need of so strictly using it. That is what I feel. But yes, someone might be, judges using or somebody using it, is it to get some sort of commercial profit out of it? If it's not there, then it's okay. That's what I feel. Yes.
And there is another thing that two persons can't perform the same.
Same. Absolutely. Yes,
There are
absolutely.
separate performers.
Which is why performers are protected. And so there could be multiple performers asking for protection of performers' right as performers. There's no problem in that. But creator could be, let's say, only one or two of them. So that means if we kind of sum up, we see that there is someone who is creating it, they are protected. Someone who is performing it, they are protected. They are protected for a certain span of time. If they want, they can give it to somebody else. If they want, they can take it back from that person. And all of this is protected under the copyright law. And one last thing, yes, this is truly the last. That is, what we protect is novelty. We do not protect an idea. Idea is not copyrightable. And hence, if you share an idea with someone and someone makes a script, that person will have the copyright, even though idea was yours. So do not share your idea, or else you write it down first before sharing it. And it's a word of caution as well, which is why I never send my manuscript unless and until I have a contract. I never send in a manuscript unless and until I have a contract. Whether you say you don't trust, maybe, but this is a problem. And that's not India. Let me not generalize it. I mean, not always India is a problem. It's everywhere. It's very easy to simply take it. So if you want to submit, that is why the custom in the film industry is that you go with the script. You don't share a script. If you hear any actors, actresses, they will always say that so and so came and we were reading the script. Or maybe either hard copy or on your iPad or whatever, that is separate. But you do not share a soft copy. So always remember that. And something that always ends whenever I talk about copyright is that there is something known as Creative Commons. We are creating commonly because we want to create something. Creative Commons. So it's always a good idea that for the betterment of the creativity, for the betterment of creatives, creating is more important. Creation is more important. So use Creative Commons. Just go to the Creative Commons website. Of course, due to paucity of time, and it's a little more technical also, CC licensing is something which is what a lot of us use in today's times. It's a different talk altogether, but do visit the website called Creative Commons. Lot of music is available, lot of songs are available. Maybe it might not be what you're looking for, but a lot of performers, a lot of creators are actually putting their work up on Creative Commons platform so that they can be more creative. As I said, artists are special. They're not like usual authors. So the case for artists is very different. I think now with that I'll end. If there's any...
Ma'am, I have a question.
Yes, please.
Supposedly, some artist, there is a tenuity for copyright, right?
Yes.
You have
Yes.
created something and it is supposedly it has a tenuity of 60 years. So after see what happened in the case of Rabindranath Tagore, he has died and it's
in the public domain now. Yes.
So we can use it.
Yes, we can use it, but we cannot claim it to be ours. We can always recreate. Yes, which is why we're adapting. Which only means that we don't have to take permission anymore. It's in the public domain. We can simply say inspired from Jaguar's so and so, I have created this. But you can't claim to be yours. That you cannot do. But till I exist, it is my copyright. I can tell my family that do not give it to anyone because it is my copyright. So no one gets to know of it. After 99 years, it will be in the public domain. So somebody gets to know it, can use it. Then the family can't say, no, I was told not to give. Yes.
One last question.
Sure, sure.
The book is copyrighted, and you can see sometimes there is all rights reserved, and the book says, the publisher says that you can't recreate this thing in also online, like doing some storytelling or something. So as a performer, can someone does that?
That is what is written under section 14. If you want, as the author of the book, you can yourself make a movie, or as I said, through licensing, you can ask somebody else to make a movie. But yes, permission has to be taken. But if it is on the commons platform, if it is published open access, then you have to give credit, you have to inform, but it's not about permission. Yes.
And how costly it is to make the contract?
Make the contract. You have to pay the lawyer. That's it. Nothing else. How much the lawyer charges? Only that much. But it should ideally be borne from both the parties. Payment of that. Yes, yes.
I have a in classical music, we can of course, since we are in Guru Shishya Parambara, we can do improvisation. But in Rabindra Sangeet, we cannot do improvisation as far the notation is concerned. So, since the Rabindranath Tagore's works are in public domain now, anybody can sing a Rabindra Sangeet. But since he did not want to do any improvisation like that, can anybody say that no, even if it is in public domain, I don't want improvisation even after my death?
No, see, improvisation is creativity. When somebody is creating or recreating something, that person has the freedom to do howsoever they want. For example, certain songs, certain Rabindra I have heard that it happens that some singers have sung it from, let's say, the last part of it. I'm forgetting Shomlata's, there is one song where she started from the second paragraph or something like that. I'm forgetting the song also. So that's possible. So it's that is definitely there. It is not like that Tagore didn't want. I don't want my book to be filmed in this manner. Someone does it, then that person can do. Okay. I think with that, I think question. Oh.
Thank you so much, ma'am. Now I request to our HOD sir for vote of thanks.
कैसा रहा? थोड़ा जोर से बोलो। और अच्छा है। आज हमने कॉपीराइट, परफॉर्मिंग आर्ट्स के फील्ड में कॉपीराइट क्या, कैसे, क्यों, कितना, ये जाना। कल हमने क्रिएटिव कॉमन्स के बारे में हमारा लेक्चर हुआ था, तो काफी कुछ उससे भी इंसाइट्स मिली, काफी कुछ जानने को मिला हमारे स्टूडेंट्स को जो ऑनलाइन थे, ऑफलाइन थे सब। और आज हमें कॉपीराइट परफॉर्मिंग आर्ट्स में वो क्या है, क्यों है और कितना है और कैसे, कितना हमारा है, कितना हमारा नहीं। बहुत सारे मल्टीपल शेड्स हैं और 2 घंटे में सबको कवर कर पाना मुश्किल होता है। बहुत सारी बातें हैं। 1-2 बात जोड़ देता हूँ जो मुझे याद आ रही। 2012 में जावेद अख्तर साहब राज्यसभा के सांसद थे, तो इस मुद्दे को लेकर के काफी डिबेट हुई। और जो कॉपीराइट थे परफॉर्मर्स को लेकर के, फिल्म इंडस्ट्री में लिरिसिस्ट को और कंपोजर को लेकर के, वो काफी डाइल्यूट थे, उसको लेकर काफी डिबेट हुई। उन्होंने काफी इसके ऊपर काम किया, और फिर गवर्नमेंट में शायद उस समय रविशंकर जी, लता मंगेशकर जी, इन सब लोगों ने उनको इंसिस्ट किया था कि रॉयल्टी को लेकर के उनके राइट्स वायलेट हुए। जहाँ तक मैं सही हूँ, मैंने उनकी स्पीच सुनी है। तो जावेद अख्तर साहब ने इनिशिएट किया और उन नियमों को और मजबूत किया। उसमें जैसा पूरा डिबेट मैंने राज्यसभा की सुनी, तो उसमें से कई सारी बातें निकली थी कि जब परफॉर्मेंस को राइट की बात हो रही थी, तो लिरिसिस्ट थे, कंपोजर थे और सिंगर्स थे, तो उसमें एक सजेशन आया था कि जो लोग डांस कर रहे हैं, जो डांसर है, उसके राइट्स की बात हो रही है, कंपोजर की राइट्स की बात हो रही है, लेकिन उसके साथ जो उसके को आर्टिस्ट साथ में नाच रहे हैं, उन्होंने कहा था उसको भी शामिल करिए, तो उन्होंने कहा कि ये पॉसिबल नहीं है। फिर उस डिबेट को वहीं छोड़ दिया गया। तो ऐसी बहुत सारी बातें हैं कि जो गोविंदा नाच रहे हैं, या कोई भी फिल्म एक्टर या एक्ट्रेस है वो डांस कर रही है, गाना किसी ने लिखा है, म्यूजिक किसी का है, सबके राइट्स की बात हो रही थी। तो वहां पर एक बात ये निकल के आई कि जो को आर्टिस्ट है उनके राइट्स के बारे में आप क्या सोच रहे हैं, जो रूल्स आप बना रहे हो उनके राइट्स के बारे में, उनकी रॉयल्टी के बारे में क्या है। तो वो शायद वो स्टेप छूट गया, उसके बारे में कुछ नहीं है कि जो मेन आर्टिस्ट है वो डांस कर रहा है, वो ठीक है, लेकिन उसके साथ जो पीछे उसके साथ जो लोग डांस कर रहे हैं उनके राइट्स के बारे में क्या है। तो मामला छूट गया। इसी तरह बहुत सारी चीजें हैं जो कॉन्क्रीट हुई, बहुत सारी चीजें जो बहुत डाइल्यूट है। धीरे धीरे करके हम वहां से चल के यहाँ तक पहुंचे हैं। आगे भी लॉस तो रिफॉर्म होते रहते हैं जैसे जैसी जरूरत पड़ती है। उसके बाद IPRS, इंडियन परफॉर्मर्स राइट सोसाइटी, कभी मौका लगे तो वेबसाइट खोल करके देखिएगा, उसको स्टडी करिएगा। वहां पे भी आपके जो कॉपीराइट्स हैं एज ए लिरिसिस्ट, कंपोजर, वो भी आप वहां पे भी प्रोटेक्ट कर सकते हैं विद रजिस्ट्रेशन। तो बातें बहुत सारी हैं, लेकिन समय हमेशा कम रहता है। तो ये जो विंडो अभी आपको मिली, आप इसके थ्रू जाएंगे तो नेट पे सर्च करिए, लाइब्रेरी जाइए, और मैडम तो है ही, कभी मौका लगेगा तो फिर से हम दिल्ली से कर लेंगे उन्हें, तो फिर से हमें और जानने को मिलेगा। बाकी आप अपने आप को और सींचिए, खोजिए, बहुत कुछ है, जानते रहिए। और आखिरी में सोमाभा जी को बहुत बहुत थैंक यू। कंटिन्यू 2 घंटा कैसे गुजर गया पता नहीं चला। मुझे कुछ और काम था लेकिन मैं उठ के जा नहीं पाया, कि सोचा कि नहीं ये पहले अच्छे से सुन ले, समझ लें। बहुत सारी चीजें सीखने को मिली, जानने को मिली। आप लोगों को भी अच्छा लगा होगा। हम आपका धन्यवाद करते हैं, और फिर से उम्मीद करते हैं कि कभी मौका मिलेगा तो हम फिर से आपको इनवाइट करेंगे, ताकि इसके बाद की जो जर्नी है उसको हम कंटिन्यू करें। और हमारे लिए, हमारे पास एक छोटा सा स्मृति चिन्ह है आपके लिए, शांति निकेतन आपके करीब है उसके लिए।
आज 2 दिन का नेशनल वर्कशॉप का आखिरी दिन है, और इसका पहला सेशन यहीं पे खत्म होता है। हम लोग वापस से 3 बजे फिर से मिलेंगे नए सेशन के लिए। थैंक यू।
Sir, can I ask a question
Yes,
if time allows? Ma'am, nowadays we see AI can generate lyrics and AI can. Am I audible? There are apps which can create tunes also, which can create songs, and there are apps which can create lyrics. You give the idea, it articulates it, you get the lyrics, and it creates the songs also. And if we upload that song anywhere, whose right it will be?
Hello. So,
ma'am.
yes. So what you are saying is basically AI generated music. As much as I can understand, so you're talking about AI generating music. So that is exactly what is the new kind of debate. And some courts have said that behind AI there is human intervention. So even if maybe AI is creating, but it's a human mind who is giving the prompt and all of that. So maybe we should be thinking of the creator to be the one who is creating it, and AI is just the medium in which you're creating.
But
So,
ma'am,
law
it
is touching on that, and of course, we don't have a law to protect and govern AI anyway, which is a problem at the moment. But however, going by the local labor theory, you can see that the person is giving the labor idea of that person. So it's just through AI that they're making it, nothing else. So
but
maybe
we don't know whose voice it is, who is singing. It sings exactly like human voice, but we don't know which singer it is.
yes. So that is exactly, so that's what I was saying, that AI is generating a voice. Whose voice is that? How do we protect? So what I'm saying is the music may be protected, but yes, whether the person who is singing is AI. So it essentially means that we're trying to protect AI. But what I'm saying is that the one who is giving the prompts to make the song, that person can be the creator, can be considered as the creator, not the one whose sound you hear. That's what I feel. But there is no clarity on that. There is no law on that as of now.
And after that, someone comes and claims it is my voice because it is very ambiguous. It's not clear.
Absolutely, absolutely. And that is what is the new challenge. So there is no law on that. There is nothing stated. And that's why it's
Ma'am,
difficult.
so generous of you to give more time to answer.
No
Ma'am,
problem.
one more question.
Yes.
Like somebody invited me to perform.
Mhm.
I asked somebody to accompany on tabla, somebody to accompany on harmonium.
Mhm.
I am given the payment and I give it to my accompanists, and everybody is recording. So uh, uh, everybody is making a video. So, who will be the actual owner of that performance?
To the one performance is yours, to the one you have given, hopefully and possibly through a contract to video record your performance. Only that person is legally the one who has recorded and can share it. But the reality is
Uh,
very different.
yes, it doesn't happen in small setup. It just happens.
No, it doesn't. It doesn't even happen in big cities also. It happens nowhere. Very few places you have that happening, and that's exactly which is why, as artists, we have to come together and have a concerted effort on this.
And the performance was with the effort of everyone. So, can
Oh
the
yes. So
accompanists?
every person, every accompanist will be protected separately, and the main performer will also be protected separately, and the entire choreography is of someone. So that person will be protected as a choreographer.
Okay, thank you so much, ma'am. Thank you so much. Thank you. Thank you very much.